Hi everyone, this is Shekhar, your host for the third episode of Ignite, and we are here with an amazing lawyer today. He is NLSIU Bangalore Alumnus. He's very soft-spoken and very witty. He has been, a part of Clifford Chance before joining the Supreme Court of India as a lawyer. He currently is an advocate on record in the Supreme Court of India for the past several years and deals with a lot of matters, specifically when it comes to the intellectual property right matters, and has been doing fabulous work in the Supreme Court of India. So, welcome to the show. Very good to have you.
Thanks, Aditya. Thanks for having me. I must say, in a lighter vein, I think I must take issue with how you've advertised this series of lectures or discussions by calling them all about law careers with super lawyers. Because I'm 33, and at my age, I don't think it's likely at all that anyone will be a super lawyer. But that said, I understand that most of our audience today is expected to be in the age group of maybe 16, 17 students who are in class 11 and 12. So it is at the same time a little bit sobering for me to realize that I'm speaking to people who are half my age. So it does make me feel a little bit old. But I hope from our discussion, they will take away something which can be useful for them to develop their own perspectives and make their own decisions.
Correct. So, Aditya, take us briefly through your day. What has been happening in your day? How has COVID-19 impacted litigation and your practice?
Right. So COVID obviously has had a huge impact on how we work. So up until March, the normal day for a lawyer would involve going to the Supreme Court. You'll be rushing in the morning. You'll rush to the Supreme Court. You'll navigate the traffic. You hope to make it in time for your matters. Then at the same time, you may have a case in the High Court, and then you have to drive across and make it to your matter there as well. A lot of that kind of logistical problems obviously are no longer there because we are all working from and having hearings from home or from office. And personally, I have a team of 5 people who work with me, and at the moment, none of us actually go to office at all. So it's completely changed the way we work. A lot of our meetings and discussions are just obviously online, and it's very rare that we actually have physical meetings with clients or even seniors because most of them have adapted very well.
Oh, superb. So, before we begin with your, with what exactly is litigation and how is Supreme Court litigation, I'd like to give the audience a brief background of how it all started for you. So, can you take us through how it all actually started? Where did you do your schooling? How did you figure out there's an exam for NLS Bangalore and your entry into this premier institute of law?
Right. Actually, so I wrote the NLS entrance exam in 2004, and the entrance exam at that time, I'm sure, was nowhere as competitive as it is today. Um, I grew up in New Delhi. I went to school in New Delhi, and there was nobody in my family here who was a lawyer. But for me, litigation, so in that sense, was not a natural choice in the sense that someone in the family would have suggested it to me. So it was a very conscious decision. And that decision came about at some point in high school, where so I was in the physics, chemistry, maths, and economics stream. And I was obviously very interested in science and economics. But at that time, I realized that I was perhaps more interested, in questions of history, language, literature, ethics, philosophy, and politics, questions of right and wrong, things which cannot necessarily be explained by formulas and theorems. So what really drew me to the law was the fact that it involved dealing with unpredictability and uncertainty, which are concomitant with human actions at every stage. So that was the context in which, even after finishing PCME, as you call it, in my 11th and 12th, I felt that law was what I wanted to do, because it was a discipline which involved, obviously it involves a lot of logical intricacies and reasoning, so it's attractive just for that reason in itself. But it also allows you the opportunity to cultivate a very wide range of interests outside of the law and see how they interact with the law as well. So it was in that with that mindset that I chose law, and I must say that I was extremely fortunate to get into to qualify for NLS, because at that time, if I remember correctly, I actually wasn't aware that, for example, all these different law schools at the time had separate exams, and I ended up writing only the NLS entrance exam, because I was not aware actually in January of that year that, for example, the NUJS entrance exam had already happened. So I thought that by the time I'll start filling all the forms and preparing for the law school entrance specifically, that was I thought that I would do that just after the board exams around March, and by that time, for example, NUJS had already happened, and so I was extremely fortunate to make it in the first attempt. So yeah, and at that time you asked about how did I come to know of NLS. I think at that time all of us would have been looking at those magazine surveys and so on, because we weren't reliant so much on the internet in those days. Yeah.
Correct. So clearly, as in the as fortune would have it, you ended up studying in NLS Bangalore, which still is the best university when it comes to imparting legal education in the country. How was your journey in NLS Bangalore? I've heard there are many interesting academic events. There's a cultural rock fest as well, strawberry fields, if I call it that, and a lot of debating also happens. And I think when it comes to less, the students have their own way of dealing with. You'd recognize a student who is from NLS Bangalore. Partially could also be attributed to the fact that you have this academic pedagogy as well. So you guys have trimester thing in which you study for 5 years. But just take us through how your life was in NLS, including debates which you were a part of, and all the co-curricular activities which you have discovered in NLS.
Right. So before I speak about how I found NLS, I just want to make it clear that actually, in my experience, obviously you have these rankings and all these, uh, opinions which say that, NLS is the best, or national law schools in general, or the universities are in some way superior and so on. I personally do not believe that at all. I think there is really there's no causal link between saying that someone is from a particular university and therefore and only therefore they would be a good lawyer or not. I don't think that kind of reasoning really bears out in the real world. It's obviously it's attractive just for the sake of opinions, but I think, like, if you just look at it statistically, because of the numbers of students who get into these law schools, and I suppose so at the time which I wrote the exam, I think the total number of students who wrote the exam was maybe only around 10,000 or 12,000. So there were some classmates of mine at NLS who, for example, wouldn't have qualified for NUJS because they had a separate entrance exam, or someone who didn't get into NALSA or anything like that. So at the end of the day, it really was a lot about how you performed on that day. But I think it's really important for anyone who is writing CLAT and is planning to pursue law as a career, that you will not eventually, not in your law school life and not certainly in your professional life, be defined by what your CLAT rank was. So I think that's something that you should really be aware of, and it works both ways. In the circumstance that you actually do qualify for NLS or any of the other you know, reputed colleges, which some people might say, you have to be aware that that's not enough. There's a lot of work that still needs to go in making sure that you end up doing what you want and you become good at what you want to do. So those things are really something which you can't automatically attach any causation just to the CLAT entrance exam. Now, as far as NLS particularly at that time was concerned, so you must realize that I think that that was a period when Nalsar, I think, was maybe only 4 or 5 years old. And a
Correct.
lot of the other national law universities were just coming about, and they had not actually, you know, really they didn't even have their first batches out and all that. So in that context, what really made NLS unique compared to, for example, other universities apart from law in India, I think, was the amount of independence given to the students to pursue their own interests and passions within the framework of the university curriculum. So NLS, apart from the courses which obviously are the same across all colleges, what really struck me as a major positive thing in NLS was how democratic it was. So if you were a first year student who was interested in quizzing and you performed better than, say, a fourth year student, you would be the one who would actually make it to the university team. And in that sense, NLS had a lot of very well inbuilt structures for students to interact and for students to develop their skills. There were a number of societies which are still there. So, for example, I was in the Literary and Debating Society, and we would have every year um, university wide selections for the university team. And it didn't matter if in the previous year you were rank one, you still had to go through that process. So that way, NLS was very democratic. And the fact that I went in with a very open mind about what I would like to experience and develop as my interests and skills in college. And from that perspective, NLS was really good. Also, obviously, there is the academic rigor, which you get used to and you have to learn to manage after some point. But apart from that, I think NLS and I think a lot of other institutions, this is not, I don't think this is an NLS specific point anymore. But the main thing is that as long as you are able to have the space within your university life to develop those other interests and develop your skills much beyond the course and curriculum, I think that would make your college experience worthwhile and something
Oh,
worth remembering.
correct. And I have heard a lot of strawberry fields and these sports events which happen in NLS. So I think Spiritus is the sports festival which happens in NLS. How was your experience in those events?
That's right. So Strawberry Fields, obviously, I think was perhaps the most well-known of NLS's events because it was a rock music festival which drew a large crowd in Bangalore and lots of bands from across the country. Unfortunately, I didn't have much to do with it because I wasn't really involved in that field. Um, but as far as that's exactly my point. So, for example, Spiritus was something which the sports committee in NLS ended up organizing. They lobbied for it and they ended up organizing it. The Literary and Debating Society was more involved with organizing the NLS debate, which also happens to be one of the most prestigious debate tournaments in South Asia. There also was a quiz and other Pictionary and word games kind of event called Legala, which was also part of the NLS Fest schedule. So I think the biggest thing which I took away from these events, apart from obviously your actual participation in those events, are really the friendships and associations you make with not just people from your batch and your college, but also from other colleges. And just as a case in point, so I was fortunate enough to have to be in the NLS debate team, and we had so I and we were involved in a style of debating which is called parliamentary debating, which I think is quite popular now, even in schools. And
Correct.
that's a form of debating which
Yeah.
has, three debaters in one team. And I was fortunate to have excellent teammates. And to this day, we remain really good friends. And it's a passion that we've carried even beyond law school. So one of them is a partner in Shardul Amarchand. The other was actually a consultant in McKinsey. And now I am litigating. But at the same time, what we ended up doing was, because we were so in love with that activity and we obviously valued our own memories and relationships so much, we actually set up something called Reason to Debate, which has been providing debate and critical thinking training to high school and university students for the past 10 years. So that's something really which we've done to pursue our passion on the side, apart from our professional endeavors.
Superb. So I think I'll share the link of Reason Debate with our audience today. If somebody is interested, they can click on that link and follow you for improving their debating style and their content in debating. Now, after you had done your college at NLS, you were placed in Clifford Chance. Is that correct?
Yes, so I graduated in 2009, and I went to Clifford Chance in London in 2010, where I completed my training contract. I qualified as a solicitor, and then I came back to India to litigate. Um, so Clifford Chance obviously is a very different ball game from litigation. And my motivations at that particular time, so even though all my internships in law school had been litigation internships, and in my head, I was pretty clear that eventually I wanted to be a litigator. To have had the opportunity that early on in my career to get the kind of professional training which Clifford Chance provides, and a lot of the other international top law firms provide, and also to be able to travel and live overseas, was something which I really valued. And that was part of the reason why I did that for a couple of years, and then I came back.
Correct. And you came back and started litigating in the Supreme Court of India. So, when it comes to litigation, Aditya, what do you exactly mean by litigating in a court of law? Because these are very young students who are slightly dicey when it comes to understanding what exactly is happening, be it a corporate advisory thing or litigation or arbitration, so on and so forth. So, what do you mean by litigation in general?
Right. So litigation obviously means going to court and arguing, or being involved in cases which are decided in courts. Litigation in itself has many different roles for different lawyers. So you'll have typically, you will, in a given case, you will have a lawyer who is actually arguing, who would be, you would refer to them as arguing counsel, which would include, for example, all your senior advocates. You would also have, in some cases, briefing counsel, or people who are involved in preparing the case on the client side. So just to give a bit of a background here. So I don't know if everyone's familiar with the distinction between solicitors and barristers as it stands in, for example, in England. The difference basically is that solicitors are involved in client facing work, which means that when a client has a case, they go to a solicitor. The solicitor helps, prepare the case, gets all the material ready, and then they brief a barrister to argue the case. So all your law firms in London are solicitor firms, which have litigation departments. And in those litigation departments, you have solicitors who are specializing in litigation. Those law firms obviously have other departments as well, not just litigation. They have mergers and acquisitions, banking, taxation, and so on. So not every case that a lawyer gets to work on is necessarily a contentious or a dispute resolution matter. Within litigation also, you have court side litigation, and then you have arbitration, and you have a lot of people who specialize in arbitrations, obviously. Now, in the context of the Supreme Court, so one of the things which wasn't clear to me, and I don't think it's something that becomes very obvious until you start litigating, is that most lawyers don't necessarily identify themselves as civil lawyers or criminal lawyers or some other specialized kind of lawyers, a lot of litigators actually tend to identify themselves with the court in which they practice. So a lot of people will say, look, I am a Supreme Court lawyer, or I'm a High Court lawyer, or I'm a trial lawyer. And this distinction is important because when after law school, whenever you choose, if you choose to become a litigator, it's really important to know what kind of work you will be getting into. Because the kind of litigation that um, happens in trial courts is very different from what might happen in the High Court, and obviously is very different from what happens in the Supreme Court. Just to put it in a nutshell, I mean, without obviously we don't have too much time to explain all of that, but to whatever extent I hope it makes sense. In any given case, you will have questions of fact and questions of law. And in trial courts, it is questions of fact, which, so obviously the trial court considers both questions of fact and questions of law. In appeal courts, which may involve obviously high courts and the Supreme Court, questions of fact are not really to be gone into again by the court. So the nature of your work in the trial scenario may involve a lot more factual speculation, reasoning, getting all the documents together. But by the time the case reaches the Supreme Court, all of that is already done. And you're basically arguing on the question of law or the meanings of certain facts or documents which are already admitted or have been held to be a certain way by the lower courts. So the mindset with which you work is very different. Personally, because I hadn't had much of a chance to intern in with a Supreme Court lawyer when I was in law school, I felt that after coming back from Clifford Chance, I wanted to make sure that I was familiar at least with Supreme Court law and procedure. So with that mindset, I joined an advocate on record in Delhi, and I'll just go into what an advocate on record is in the Supreme Court. So normally, what happens is, once you're an advocate, once you have enrolled, normally speaking, you would be entitled to file a case and argue a case in whichever court you want to. The Supreme Court has an additional exam, which is called the Advocate on Record exam, which requires 4 years experience and 1 year of training with another advocate on record. And only those advocates on record who pass that exam will then be permitted to file cases in their own name in the Supreme Court. Now, what that means is that, as I mentioned earlier, in a given case, you can have some lawyers who are arguing counsel and others who are, on the client side preparing the case. So, an advocate on record will typically necessarily be involved on the preparation and client side. And in a lot of cases, you will see that the advocate on record then engages a senior advocate or an arguing counsel to argue their matters. Now, that's not necessary. A lot of advocates on record also argue their own cases, and that's really up to the client, and it depends on a case-by-case basis. But that division of functioning is something which you can draw an analogy with maybe the solicitor and barrister system as it used to be, as it is in England, because in one sense, you could say that the advocate on record fulfills the solicitor function, and the arguing counsel or the senior advocate fulfills the barrister function. But in India, there is no bar on the advocate on record fulfilling both those functions, and there are many instances of advocates on record who have become senior advocates subsequently, and even Supreme Court judges.
So a very extensive way of explaining what exactly is an advocate record, who is a senior counsel, how are the trial court litigation is a trial court litigation quite different from a litigation in a high court or court. Now, before we proceed ahead, Aditya, I would like to understand the importance of debating, of structuring all of these basic essential characteristic traits should be there in an advocate who wants to, or in a graduate who wants to do well in litigation. So since you have been a part of the debating society, and you have been part of these societies which make you think and understand a particular argument in a proper way, what do you think are some of the characteristic traits, or what are the things, what are the prerequisites for a person to do successful to have a successful litigation practice in any courts in India?
Right. I think one thing for litigation specifically is that you must have a very wide interest in law in general. So law as a discipline in itself, as a field of study in itself, is something which you should be excited by. Unless, for example, you are sure that you are interested in a particular area of law and then you want to do cases only in that field, which is also fine. Um, I think, I mean, as far as debating and mooting and other college activities are concerned, what I would say is this: see, none of those activities, or actually a lot of things in law school, don't really prepare you for litigation at all, because a parliamentary debate is nothing like a court hearing. In my experience, like what makes arguing in courts really challenging is that it's always going to be unpredictable. It's like a good litigator will basically be able to predict the course of a conversation. You don't know how the judge will react. You don't know what the other side will say. So that is something which debating doesn't necessarily fully equip you for. And I think just in terms of students who are looking when they join law school, what are the kinds of activities should they get involved in? I think the most important thing is to be true to yourself. You should see what is it that you enjoy doing, what is it that interests you, right? And if there are certain skill sets from those activities which you think can translate into something else, then you can pursue those activities as well. But it's not, for instance, that debating will automatically make you a great litigator, or mooting will also make you a great litigator, or it is necessary to be involved in mooting to be a successful litigator and all that. So a lot of that is just picked up on the job, because law school doesn't really prepare you for the professional world. It gives you a basic framework of information which you can use to hold your own when you're in the professional environment, but it doesn't give you these skills automatically. And just on that, what I would also say is that I think a lot of times when students join law school, um, you always have this, I mean, through word of mouth or through your friends and peers, you have this perception that, look, either I have to become a litigator or I have to join a corporate law firm. The truth is, legal education and law is actually something which prepares you for things much broader than that. So a lot of what your legal training will equip you to do will enable you to be a participant in interdisciplinary activities. So for examples, there are very prominent examples of people who have become academics, not just in law, but in other fields such as history or politics. And they use their legal training as the basis for that. There are others, as I mentioned, people who have gone into business consulting, others who have started their own businesses. So I think, especially at the stage when you're still writing CLAT, I think it would be a huge mistake to say that, look, 5 years from now, I know exactly this is what I want to do. The most important thing will be that you need to keep your mind open. You need to experience as many things as possible. See how different workplaces and work environments are comfortable for you and how they are not. If there are things and skills which you need to change or work upon to make yourself more suited to certain work environments, then you should work on that. But at the end of the day, don't make the decision based on what everyone else is doing, and not based, and also not based on just what your friends are doing, or what hopefully what your parents are pressurizing you to do, and so on. Because I'm sure that's a huge concern for everyone. Even in my batch at NLS in 2000, so I graduated in 2009. I think there are not more than 8 or 10 out of the class of 80 who are litigating now. And I am not one of those who says that, litigation is the purest form of law practice and all that. That's not something which I subscribe to at all. There are extremely talented lawyers who are in various corporate law firms, and they are doing what hopefully they find most interesting and worthwhile. So I think the most important thing is you have to keep an open mind and make sure that you are doing something which you actually enjoy and will find meaningful.
Great, great. So we will open the floor for people to ask questions now. Anyone who wishes to ask Aditya anything with respect to how he has transformed, how he has, taken the leap into litigation, all of you can write the questions on the live chat window. Before I move to that, I would like you. I would like to. I would like you to answer one question with respect to the best case which you have argued till date, or the best litigation experience which you have had in Supreme Court. So it could be anything, any good experience which you have had with in the Supreme Court of India.
Yeah, so I think so in the context of the Supreme Court, I mean, I've been involved in a few high-profile cases, which I don't want to go into the names and all that. But personally, as a lawyer, one of my probably the most memorable experience, which I think a lot of Supreme Court lawyers will have at some point, is the first time you argue a case in the Supreme Court and the judges agree to issue notice in your matter, which and I mean, and that's a huge thing, simply because I think statistically about 85 or 90% of Supreme Court cases get dismissed at the first stage of admission itself, right? So you have to understand that in that context, if you are able to argue and convince the judge that yes, this is a case which merits interference, that's something which you always remember. And that for me happened at some point in 2014 or 13. And I was extremely thrilled when that happened. So yeah, obviously it wasn't a huge case, but for me it's quite significant.
Right. Super. So let's look at some of the questions. Abhishek Christie says, "Can you give some pointers to improve one's debating skill?" Okay, this is something which would require an extensive explanation, but a couple of pointers just to improve the your debating.
Yeah, please read very widely and read opinionative articles and books, and please go out of your way to engage with people who disagree with you. I think that's the best way to become better at debating.
There's an interesting question by Shania Singh. She asks, "There's a myth like litigators have to suffer more than corporate lawyer. Is it?" Go ahead
Right. I
and
mean, I think
answer
that's the thing. So, I mean, it's suffering only if you don't want to do it. But yeah, it's obviously it is hard work. So one of the things that happens in litigation is that a lot of times you're dealing with cases which require almost emergency responses. So something has happened today, and you need to file something by tonight or by tomorrow morning, and get the case listed and heard and prepare everything. So in that sense, it is very stressful for some points of time. So what that means is that you don't necessarily have full control over your schedule all the time. But I think in the context of suffering, there's the other aspect of it. Obviously, is that the gestation period for young litigators is obviously longer than in corporate firms, and that's because, I mean, obviously corporate firms have very relatively streamlined processes for promotions, and there's also the I think the financial comparison is not really fair in some way, because once you join a corporate firm, you are signing up basically to serving clients who would, for example, more often than not have certain commercial issues to resolve. And if it's a commercial matter and you have, say, a corporate which is actually funding it, or who's concerned by that case, then the amount of money which the corporate firms charge and concomitantly what younger associates even in those law firms receive is much more than, say, a fresh litigator who may be dealing with a case which has not, which doesn't have much of a pecuniary value for anybody, but you're still required to put in your best. The other thing is that in litigation, and I'm just going back to what I said earlier about how, especially in litigation, you can't be a super lawyer at 33. The point is that litigation is something which, for a lot of for a lot of the very successful lawyers, has been a lifelong passion and a lifelong discipline, right? So if it's the kind of thing which a lot of people have maybe become, the best, their best and the best in the profession at, say, at the ages of 50, 55, 60, and so on, it's quite understandable that for the first 7 to 10 years, your contribution to a case and the ability even if it's your best and even if it's better than a lot of people at your age, at the end of the day, it's not necessarily something which would be the best in the business just at that stage. So understood in that sense, what happens is that for a lot of senior lawyers, junior lawyers are not necessarily they're not necessarily required in each specific case. So what happens is when you start off litigating, the biggest gift you can get is the experience of a wide variety of cases, right? Just to hone your understanding, to become aware of procedural law, which is something which you don't have much of a grasp of in law school, even if you've even if you've understood corporate and contracts law in law school. So in that sense, yes, the struggle is longer, and obviously, unfortunately, like salaries in litigation are nowhere close to what would be the case in corporate law firms. But that's something which obviously the profession has to face and hopefully resolve at some point in the future.
Yeah, but I think, Aditya, having said that, the gestation period, of course, is longer. But then once you are able to come up with your own clientage, then the proportion with which you can buy money it's simply unparalleled, and you cannot compare it to a job as well. So that of course is true, and I'm not. But then I've seen people who take up litigation an anticipation of getting money after they have had substantial amount of experience. So 5-10 years down the line, they would be earning money which would be disproportionate. So that is something which, of course, persists. I'm not sure whether to use disproportionate the term correct. Of course, that is something which is I think prevalent.
Yeah, no, you're absolutely right. I think so. The once at the extreme levels, in terms of financial gain, litigation is probably unmatched at the highest levels. But I think, see, if you're at the stage where you're writing flat, or even when you're getting into the legal profession, I don't think that's something which should be bearing on your mind too much. Now, what I would say is a couple of things, though. That in litigation, because one of the things which is different about the litigation recruitment market as opposed to the corporate law firm recruitment market is that it is far more opaque. So in litigation, for instance, as of now, I don't know how many lawyers in Delhi today are actually looking for a junior right now. Right. But with corporate law firms, you have a kind of predictability that look, every year they'll come and recruit 10 people from this college or 15 people from that college. So, and you know exactly how much each person is going to be paid in advance. So that kind of opacity is obviously there in litigation, which is what makes which is what makes it really important as a law student and as a young litigator to forge very strong relationships with other people in the profession. And what I will say is that obviously, when I started off litigating, you have this constant apprehension that, look, there's nobody in your family who is a big litigation name. The profession has some, reputation for nepotism and all that. All those are concerns which are there in the background. But I think what I have found, fortunately, is that if you are actually if you are actually litigating because it is an end in itself for you, you actually enjoy doing it, you will also end up associating and forging relationships with other people in the profession who feel the same way. And what I will say is that those who are at the top of their game in litigation are, are actually very committed to their craft. They are very committed to the integrity of the profession. And if you actually happen to meet them or you happen to work with them on a case and you impress them, then it really is something that may pay off, like both professionally and maybe financially, at a future date, right? So that's something which you have to be very flexible and almost philosophical about, that you have to keep doing something which to your to the best level that you can, without necessarily expecting it to have a clear outcome just then. So I think that patience is something which you need to have, but it's worth it if you actually enjoy it. So yeah, I mean that's something which someone should bear in mind.
Correct. Yeah. So Vipul Parashar, he asks, how do we go about searching for internships in law school, and how do we be more competent to actually get such internships? So taking you back to your college
Yeah,
life.
yeah. No, I think that's a very, very good question. That's a very good question.
Correct.
I think, right. So as far as first and so, I mean, I just say what so my internships all ended up being litigation internships, because for whatever reason I was in Delhi. I felt that, from at least second year onwards, that I was pretty clear that I wanted to be a litigator eventually. So for me, that was a kind of a natural choice. But I think, especially in your first, second, and maybe even third years, it's really important to try to see where your own interests lie. And especially, I think, because the way the course is designed, the first 2 years don't really equip you with much for as far as the legal training side of it is concerned. So a lot of people I know have interned in non-law organizations. They've got work experience in different environments, in different places, depending on what their interest is. So I think the most important thing is obviously to just ask what you are interested in, what would you like to develop the skills for, and then search for internships in that field. In litigation specifically, it's not a bad idea to write to advocates, senior advocates, or advocates in other cities or wherever you are based, um, and write to them. Like, obviously, you have to demonstrate that you are personally very interested in interning, because, as I said, even a new litigator may not be contributing that much to a litigation office right away. So the contribution which the intern will make is not obviously going to be even of that much value for the litigation office. So you need to understand that you communicate your passion. You need to ensure that you are doing it not just to pass your time, but something which but to actually demonstrate your interest in something, and just work on those relationships. I think that's the most important thing.
Correct. Siddharth asks, being in litigation, is there a possibility to be appointed to the judiciary?
I'm sorry, just can you repeat that?
He asks, being in litigation, is there a possibility to be appointed in judiciary?
Yes, of course. I mean, a lot of, I think pretty much every judicial officer, except maybe those who are in the district court who have written the judicial services exam straight without litigation experience, maybe. Yeah, that is obviously one of the career trajectories for litigators, to become a district court judge or a high court judge, and in some cases a Supreme Court judge. So yeah, that is there. But I mean, obviously, the trade-off with that career path is that you retire, unlike a litigator who can actually choose just to not retire, or can retire for some time and then come back. So that
Correct.
flexibility
Correct.
is something which obviously
Exactly.
you don't have.
So Aditya, I just want to have one question. When it comes to judgeship, so you are appointed as a High Court judge. For instance, after litigating in a High Court, you are selected by the chief committee, the collegium elects you. After you have attained the superannuation, where can you practice? So, for instance, if a person who is practicing in Delhi High Court and Delhi, and he has been made as a judge of Delhi High Court, can he practice in the Supreme Court or in any other high courts for that matter?
Yes, they can. I think there's a provision in the Constitution for that. I think it's either Article 215 or 217 or one of those. But that specifically, basically, that the way that that's worded is that you won't practice in the High Court where you were a judge. So by implication, it excludes other High Courts and the Supreme Court. So there are actually quite a number of very successful senior advocates today who were High Court judges.
Okay, right, super. Let's look at some other questions. Vaibhav asks, sir, please tell us about LLM being a better option to get jobs and placement in UK and US. Quite that foreseeability is, I think, there in.
Yeah, no, I think that's a very valid question.
Absolutely.
Now, that's a very valid question. Right. So I'll just explain this. Basically, a lot of these global law firms, when they recruit from across the world, they don't necessarily require you to have a master's degree. But fortunately or unfortunately, that kind of recruitment is restricted to what you would call, the top law institutions and so on. So in that sense, yes, it does make sense sometimes to pursue an LLM abroad, so that it might make you eligible for certain kinds of work experience or even job offers at some of those firms. But that said, in my experience, but I don't have any statistical data to back this up. What I have felt is that probably eventually, if you have the idea that you want to work in an international law firm, just generally, it's probably worth getting relevant work experience in an Indian firm in the same department or in that same area. And then after a few years, maybe apply for a lateral recruitment to one of those firms. And then obviously you manage your qualification. For example, UK requires qualified lawyers transfer test and so on. It used to be called the QLTT earlier. Now I think it's called the QLTS and whatever. But I'm not so sure that an LLM alone is something which increases your eligibility for a permanent job offer at foreign law firms. I don't have the data for this, but that's my sense. Like LLM is something which I felt, either you do it because, for example, that you want to, for example, be a litigator later on. So right out of law school or a couple of years after law school, you will do an LLM and then you'll come back to litigation, or you'll come back to the job to the firm or to the area where you were already. Or you use that as a launching pad for an academic career in law. I am not so sure that LLMs increase your value, so to speak, to foreign law firms for recruitment directly.
All right. So I think we are done with the question. I had a lovely time interacting with you, Aditya. I got to know a lot of things about Supreme Court, the varied practices followed in the various courts, your background, NLS, and all of this, I'm sure, has helped our viewers to understand the importance of academics, how you're supposed to go about your careers, what exactly litigation, all of that. I think we have extensively covered. So we wish you the best in your career endeavors.